योगः कर्मसु कौशलम्.
Thank you so much, sir. At the outset, I am very much thankful to UGC Human Resource Development Center of Gujarat University for giving me this opportunity to connect with you and to share some of my views on a very relevant and contemporary topic related with the working class or labor. And to them, I always call that they are the nation builders. In this series, first of all, I would like to say thanks to Dr. Jagdish Joshi ji, who is Professor and Director of UGC Human Resource Development Center of Gujarat University, and on whose kind permission I am with you. So thank you, sir. Though I was called by the organizer as a guest speaker to speak in this event, but the way of inviting me to speak in this event, it was really heart-touching for me. So I never feel that I am outsider up to this Gujarat University. So in this regard, I would also like to say thanks Dr. Bhavesh ji Bharat ji, who is coordinator of this event, for providing me this opportunity to speak on the issue and to deliver today's session. Dear friends, I, Rajneesh Kumar Patel, Faculty of Law, Banaras University, feels privileged to be with you. And the topic which I have chosen to speak on this today's session, that is industrial workers, their human rights and the new labor codes in India. Dear friends, as you are aware about this fact that Human Resource Development Center of Gujarat University is ranked as a 15th in India and the first in Gujarat, this pioneer institution has created the history and benchmark by organizing the regular academic events and the first of its kind of online program was held in 2018 and 19, in which about 2,500 participants has participated. Similarly, the first of its kind of online research refresher program in English language, it was organized, and in which about 9,000 participants has participated. Similarly, there is another example in the year of 2020-21, another English language teaching program was organized by this institution, in which about 3,500 participants has participated in the program.
Dear friends, now moving to the topic, industrial workers, their human rights and new labor codes in India. In this topic, we will focus on the trend which is going on in relation to the workers' human rights at the global level and along with the Indian position. We will divide the entire discussion into three parts. Firstly, we will try to understand the concept of human right, and then we will focus on the term globalization and its effect on the labor's right. Particularly and especially, purposely, I have added this point also in our discussion because I personally feel that globalization has also affected the rights of the workers. And finally, we will focus on the four labor codes which are very recently passed by the Indian government and which amalgamated about the 29 workers legislation into four codes. Mainly, we will try to discuss the effect of these codes on the interest of labor. So, dear friends, I would like to start my presentation with this famous line that history of labor struggle is nothing but a continuous demand for a fair return to their labor, which is expressed in the varied form like demand for increase of wages, grant of allowances, leave, good human working condition and other benefits, etc. Friends, one of the major side effects of the rapid industrialization was the exploitation of labor. Therefore, long working hours, poor wages, poor safety conditions, unhygienic and hazardous working places, child labor, and total lack of job security are the major problem in the field of labor. It should be noted, friends, very carefully that in regard to the condition of labor, even the international community, it also found that workers are not in a position to dictate their employers. They had to accept unfair service conditions as they were always in a lower position. There was no doubt that labor needed the protection and it was necessary to ensure some of the basic minimum conditions. So, friends, various labor laws were passed to protect their interest and the interest of the workers, and side by side, the trade union movement also took roots so the workmen can become united and get their legitimate rights. But friends, believe me please, it was not an overnight journey. Actually, on both national and international level, the issue of labor has been subject matter of great concern, particularly the role of United Nations and the International Labour Organization in this regard is very much appreciable. So now move to the United Nations and its role. First of all, I would like to put this fact before you that United Nations institutionalized the entire idea of human rights. First time at the global level. You may consider it as the first international legal framework for the protection of human rights, which suggests some international legal norms, and these norms are putting a duty on the state, and that state have to protect the human rights and freedom of the individual, including the working class. Thereby, it also limits the power of the state, which is very purpose of having the international laws. Now the question is that what are the legal obligations of the state and how they have been implemented against the state. Friends, as you are aware that this United Nations has worked for the protection of human rights at the international level, and the agencies which have been constituted, created by the various international documents, they are constituting some mechanism, enforcement agencies, and through which the states are now bound to implement the international obligations. In this regard, some conventions were adopted under the auspices of the United Nations. You can say that they are the legal framework for the protection of human rights. These instruments will apply to all the states, barring restriction that state must be the member or signatory of the same. Friends, there are a number of international documents, but about 9 conventions which are considered as a core convention of international laws. Actually, they have established the monitoring body, and they are responsible for the protection of human rights, wherein not only the state but the even individual can claim their rights. It is very much important to note, I will repeat the same line, that not only the state but individual can also claim their rights under these mechanisms. And friends, as you know that apart from these 5 core conventions, there are also various optional protocols which are also devoted with the same intent. Moving further, I will say that all these international documents, including the Covenant of Civil and Political Rights of 1966 and Covenant on Economic, Cultural and Social Rights of 1966, they have established the mechanism to enforce the human right in a particular state. Friends, as we were discussing that the legal framework for the protection of human rights start mainly with the establishment of United Nations, Actually, this was an idea to achieve the international peace and security as well as to have a check on violation of human rights. United Nations is the first official charter which was established in June 1945 and comes into operation on 24th of October 1945, where we can find the reference, the first reference of the human rights phrase. Prior to that period, the term human rights was used as a natural rights. Even in the League of Nations, the word human rights was not used. And after the United Nations contains several provisions which were devoted to the two main purposes. The first was international peace and the second was to promote respect of human rights on international level. So friends, now move to the second agency in relation to the labor issues, as you will be remembered that in 1919 the first political organization which was similar to the United Nations was established after the First World War, and it was the League of Nations. On the other hand, another organization which was not a political organization, it was also established, and it was the International Labour Organization. The International Labour Organization was the economic and social institution, and it was devoted to improve the status of workers and for their welfare. The main motto of the ILO was that unless we address the problem of inequality, poverty, we cannot even imagine for the you can say the protection of human rights and also the peace of international labor. So it requires making any attempt on a ground level and not only as a sweet smoke to misguide the public, or which can be used for the political gain, you can say, or that to collect the vote in the election. So this is the reason that it is expected from all the countries that they have and they should cooperate in this regard and prepare some domestic law to ensure the equality and to make a real and hard work to implement the international obligations. Actually, the International Labour Organization is a special agency. If you look into the Constitution of Ilo as amended after the Philadelphia Convention, you will see that it added most inspiring and encouraging line that unless we achieve the social justice, even we cannot think about the international peace. Similarly, it is also written there that the poverty in any form is the threat to the humanity and prosperity anywhere. Therefore, those who are really willing to establish the international peace, they should try to remove the poverty first. It is a very important line that those who are willing to remove the poverty, remove the and to establish the therefore those who are really willing to establish the international peace, they should try to remove the poverty first. At least there should be equal distribution of any kinds of right. For example, friends, as you are aware that the entire globe is now under a pandemic attack. For example, friends, nowadays the entire globe is under a pandemic attack, which has not only unlearned the reality of our medical as well as the total system, but for example, now the entire globe is under a pandemic attack, which has not only unlocked the reality of our medical as well as our total system, because everything comes in black and white. It also defines the personal relation in a new way. It raises the question of health issue as well as the problem of workers, particularly the migrant workers. So, just I wanted to repeat the same line that those who are really willing to establish the international peace, they should try to remove the poverty from. At least there should be the equal distribution of any kinds of right. Friends, as you are aware that nowadays the entire globe is under the pandemic attack, which has not only unlocked the reality of our medical as well as our total system, because everything comes in a black and white. It also defines the personal relation in a new way. It raises the question of health issue as well as the problem of workers, particularly the migrant workers. These issues are directly related to the human rights of workers because providing the health or right to health to all the citizens and also the livelihood is the prime duty of any welfare state, in which during pandemic we were witness of great violation. And being a student of labor law, I don't feel any type of hesitation to say that it was really a failure of the system. Therefore, to make sure that that past day never repeat, we should collectively think on the both of the issues. I may say that is the right to health as a fundamental right, and the protection of interest of labor not as a slogan but in a real. Now moving to the Constitution of ILO, as the Constitution of ILO itself says in this regard that universal and lasting peace can be established only if it is based on the social justice. Coming to the background also of ILO, you know that after the First World War, the International Labour Organization was established in the year of 1919, and it is really a great that this organization in its total of 102 years of its journey speaks at least 206 times through its recommendation on the labor issues. From its origination period, that is 1919, there is only 13 years in which its recommendation not comes. Otherwise, in each and every year between 1990 to 2021, it has given its recommendation and sometime more than 5 recommendations in a single year. During the same period of about 186 conventions have been passed relating with the labor issues. Keeping the vulnerable position of labor in mind, the International Labour Organization, it recommended a number of suggestions for the protection of the workers and their overall betterment. Friends, it is very much fortunate that whenever the ILO recommended anything, the same has been accepted and implemented by the Indian government by making a new legislation for the protection of their human rights. It is significant to note that most of the ILO conventions related to the workers adopts a human rights approach in addressing their issues. According to the preface of ILO, Declaration on Social Justice for a Fair Globalization 2008, by adopting the text of representative, the governments, the employers and the worker organization from 182 member states emphasizes the key role of tri-party organization in helping to achieve progress and social justice in context of globalization. The declaration is built on the value of principle embodied in the ILO Constitution, and it reinforces them to meet the contemporary challenges and the issue related with the human rights of the working population. So this is all about the International Labour Organization. Moving further to the Philadelphia Declaration of 1944, I have to say that this Philadelphia Declaration of 1944 is very much concerned with the overall protection of human rights of workers, and you may see in these four principles. The first principle is saying that labor is not a commodity. They are the human being. Secondly, it is also saying that freedom of expression and association is essential to sustain progress. Poverty anywhere constitutes a danger to the prosperity. And finally, it is saying that proper representation of workers is very much essential. All these four guidelines are unique, and it should be have their universal application for the protection of overall rights of the workers. And moving one step further, friends, prior to the emergence of global human rights discourse, rights assumed to the citizens by different states were diverse. The concerned state was itself at the reference point. The ultimate authority and the arbiter in the terms of such rights, there were no uniform standard globally assured or acknowledged with regard to the rights. So, it was actually with the event leading up the Second World War and the war itself that concern for the human rights came to the fore. You are aware that the Nazi atrocity in the Germany and the horrors of the war were the major cause concern, and across the world there was a fear of such history being repeated and perhaps in a more dangerous form. So friends, in this regard, the Declaration of Human Rights is also having its significant effect. Therefore, against this backdrop, it was felt that human rights added and needed to be standardized on urgent basis. The concern was voiced by the representative of 26 nations, and that were the fighting for the Axis power in the Declaration of the United Nations in 1942. In the document, the signatory spoke of the need to preserve human rights and justice in our India as well as in other countries. During the Second World War comes to end. Thereafter, in 1945, the representative of 50 nations, they met at San Francisco to draft the United Nations Charter, and again in 1948, the adoption of Universal Declaration of Human Rights. It was a great attempt towards the human rights at a global level. Here I would like to mention one special thing that about the India, that we the Indian citizens were very much fortunate. Why? Because when the international community were busy in drafting to this human rights declaration, at the same time our founding father of Indian Constitution, they were also preparing the draft of the Indian Constitution, and therefore most of the mandates of this declaration we have incorporated under the Constitution in the part 3rd of the Constitution particularly. And whenever our founding father of the Indian Constitution, when they feel that this newly constituted government will be not able to provide any of these rights, instead of taking out, they have added, they have incorporated under the part 4th of the Indian Constitution as a desired goal of the Constitution and desired goal of the government also. After Declaration of Human Rights in 1948, various institutional devices have been resorted for the protection of and promotion of the human rights. Today, all the mechanism what we have already discussed about the 9th Convention, each mechanism operates at a regional level, national level, as well as the international level, and all they are devoted to protect the human rights. So, dear friends, you can imagine that how the labor issue is essential and how the international communities are trying to protect their rights by adopting the international norms in their own national laws for the protection of the human rights. So now, let me permit to begin with the concept of human rights. Here the first question is, what is human? Human rights are defined as a basic rights They are the natural rights and they are inalienable rights. In a very simple way, we can say that the human rights are those rights which are available to all the human beings, irrespective of their caste, their culture, their race, their religion, their nationality, or their citizenship, etc. Actually, they are some basic, elementary, and common rights. They are universal in character and equally they possessed by all human beings everywhere. It means every person on this earth, without discrimination, irrelevant to merit or need, simply for being human, is entitled to the human rights. It did not require any qualification, and human rights have no conditional boundaries or limitation or criteria for its application. And there is only one parameter you can say, that if you are a human being, you are entitled to avail all the human rights. This idea of human rights can be traced from the ancient text and time. It emerged from the natural law philosophy. It is not purely legal theory. Anyone can trace this history long back to the 500 BC in a Greek or Roman law tradition. Similarly, the Hindu religion and the Hindu religious text were also containing the idea of human rights, and not only this, but even in Islam as well as in most of all the effective religions, you can say that they are. You can find that there are number of examples of the same idea. So this is very common definition of the human right. Now come to the statutory definition of the term human right to understand this concept. Friends, under section, you are aware about this famous act of the Protection of Human Rights Act 1993. Under section 2D of the Protection of Human Rights Act 1993, it defines the human right as that human right means the rights relating to the life, liberty, equality, dignity of the individual, guaranteed by the Constitution, are embodied in the international covenant and enforceable in law courts in India. So this is the definition which is given under this act. I will say one thing, especially in this regard, that it is a very good definition, no doubt, but really it has two main limitations. First, as per this definition, only individual rights are the human rights. Even it was true at the point of time when the human rights were recognized only as individual rights, but after the introduction of the third generation of human rights, the definition is not true and having its limitations. Secondly, friends, this definition is given only in the context of enforceability, and it is saying that it is given under either the Constitution or international covenant, and it is enforceable through the law courts in India. Then only it can be said as a human right. So this definition is restricting the term human right under the boundaries of the enforceability, which is not correct to say. As far as its enforceability is concerned, human right may be or may not be enforceable. But even if it is not enforceable, it can't be thrown outside of the definition of the term human right, because human right need not necessarily be a legal right. I will repeat the line that human rights need not to be necessarily be a legal right. It will be a sufficient that if they are the moral rights. So these are the two conventions also. It also talks about the this enforcement of the human right. And finally, coming to the enforceability, the question of enforceability, as we have discussed that human rights are the moral rights, but one should always keep in the mind that if they are also having the mechanism to enforce, it is important to say this line forcefully, that the states are the main target and simultaneously they are also the protector of human rights. It also includes those institutions who can exercise the state-like power. The word enforceable means everything which could get legally by a person through the course of law or under the law. In this way, the this right may be different types depending on the fact that where it has been provided. For example, if any right is given under the Constitution, then it will be constitutional right. If it is the same right is given under the Part 3 of the Constitution, then it will be called as a fundamental right. If it is given under any institute, then that will be the institutory right. And again, if it is otherwise recognized, then it will be called as a legal right. So therefore, any right which is available to all human beings, and if those rights are protected or recognized by any law or by the Constitution, then the same can be said as a legal right, constitutional right, institutory rights are the fundamental rights. So now, as I was discussing that some examples can be taken in this regard of enforceability, particularly the Covenant on Economic and Social and Cultural Rights recognizes certain rights as a human right. Some of those rights are also written under Part 4 of the Indian Constitution as a directive principle or a state policy, and therefore they are not enforceable by the law courts. However, some of these rights are now recognized by the Supreme Court. For example, right to education. So, it is clear that right to education is not merely a human right, but in its lower pedestal, it is also a fundamental or constitutional. It is important to note that even if it is not written under the institute or any jurisdiction, it will remain human right. Therefore, enforceability is not essential for human right. Even it is not written under the Constitution, it may be declared as a part 3 of the fundamental right. For example, right to fresh water, right to sleep, right to environment, right to speedy trial, and so many others. These are included under the Article 21 of the Constitution by the Honorable Supreme Court of India. So, moving further, friends, we were discussing about the enforceability of these human rights. So, it will be necessary to have a little focus on the components of legal rights. Friends, actually there are two types of components, or two things are necessary for to being a legal right. The first is the holder of rights, and the second is the person bound by the duty. Dear friends, we have discussed that even any right is not enforceable, that may be designated as a human right, but friends, without being enforceable, there will be no meaning of those rights. So therefore, due to this reason, even under the international document, there is clear duty assigned to the signatory for observing the obligation written under the such treaty or the covenant. So we can take the examples also in this regard, and that example will be the Declaration of the Human Rights Defenders 1998. Its Article 2 para 1 provides that each state has the prime responsibility and duty to protect and promote and implement all human rights by adopting necessary measures. So this is the duty which we were discussing, that even at international level, they are not, these provisions are not only in a vacuum, they are having its enforceability power. Secondly, Article 2 para 2 of the same institute, which is saying that each state shall adopt necessary legislative, administrative and other steps to ensure that right to protect human rights is effectively guaranteed. Further, the International Covenant on Civil and Political Rights and International Covenant on Economic, Social and Cultural Rights stipulated in the preamble as to the obligation of the state to promote universal respect and observance of the human rights and the freedom. So, friends, we have seen the definition of human rights, and the issue related to the enforceability. Further, the human right can also be defined as the internationally recognized rights. It means if on international level it is recognized, then it will be the human right. But the question is that who will recognize the human right? The member state? No, not at all. Under international institutions, but under the domestic laws, particularly after Second World War, almost all the countries, they have been given prominence the concept of human rights. I mean, who is the provider of human rights? One minute before I was saying that all these rights are internationally recognized rights. What it means? It means that member states can recognize the same. It should be noted, friends, very carefully, the states are not provider of the human rights, because human rights are the high pedestal rights and they are already recognized right by the natural law or the law of nature. Hence, being the part of natural law, you can say that there is a supranatural power who created these rights, and the supranatural power is the actual provider of these human rights. You can say that he is the God. Yes, friends, God is the provider of human rights and states are not provided. They are already recognized and states are only making to the law to make available to the human being to protect those rights. If you wanted to have an example in this regard, you can check the wordings of the various articles given under the Indian Constitution. Particularly, Article 21, friends, it is saying that no person shall be deprived from his life and liberty except according to the procedure established by law. Similarly, Article 14 is saying that states shall not deny to any person equality before the law or the equal protection of the law within the territory of India. Therefore, the states shall not deny, the states shall provide. What it means? It means that these are applicable against the state, clearly meaning by that there is one superior authority which orders to the state not to deny the human rights of the people. This is the reason why the human rights are having the high status, and you can say that any man-made law, including the Constitution of any country, states are only facilitating that they are, you can say that they are only protector of the human rights. And if they will be prepared, they will prepare any law that will be tested and must be tested on the parameter of natural law. It is the clear meaning that the constitutional mandates are also recognized by the natural laws, that is the human rights. All the states are bound to respect the same. It may be forgivable that the state is not in a position to implement any human right in its jurisdiction. And that's why it did not make any specific laws in the country for providing the same to the citizen as a statutory right or constitutional right or legal right. But still, it will come under the definition of the human right. Thus, the rights which were treated as a natural right to a person are now, after the Second World War, it is described as a human right. So, before moving to the other issue, you may note, friends, some important point in regard to the human right. We have seen that firstly the human rights are the universal rights. They are equally present by all human beings. The idea that every human being is entitled to certain common rights assumes that all human beings are equal. They are inalienable in the sense that one cannot legally waive their rights. Thirdly, human rights are held against state and quality of the state's power. Further, the human rights are not absolute. Remember human rights are not absolute. They are restricted as much as it is necessary to secure the comparable rights of others and the aggregate of the common interest. So friends, we have discussed also about the enforceability of the human rights and the role of the state. Now, actually, we were also discussing about the various generation of the human rights. So, have a look on this issue also, generation of the human rights. The concept of three generations of human rights is inspired by the three themes of the French Revolution: liberty, equality, and fraternity. You are aware about this fact that liberty corresponded to the first generation of the human rights. Similarly, equality corresponds to the second generation of human rights, and fraternity corresponds to the third generation of human rights. And all are related with the French Revolution. It is important to note that the first generation refers to those civil and political rights that derive from the natural law philosophers such like Locke, Rousseau, Jefferson, and others, who strongly pleaded in the favor of freedom. For them, desire for the freedom is deeply rooted in every human being. Jefferson especially says that liberty is an inherent and inalienable right of human being. Kant also declared that freedom was the one sole and original right which belonged to the every human being by virtue of the humanity. Therefore, the first generation of human rights related with the freedom or liberty to an individual, like freedom of speech and expression or freedom against exploitation. Some of these rights are mentioned under the covenant of civil and political rights. As a matter of fact, these rights are also protected under the Indian Constitution as well as by the certain legislation. Moving further, the second generation of human rights are concerned with the equality. These rights are termed as the economic, social, and cultural rights. These are given also under the covenant on civil, economic, social, and cultural rights. And in India, these are written under the Constitution, particularly Part 4 of the Indian Constitution, which are particularly not enforceable by the court of law. Finally, the notion of the third generation of human rights emerged recently. This idea is that the addition of the individual rights belonging to the first and second generation, there are collective or group rights, such as the right to development and the right to self-determination, or you can say the right to environment. In fact, the concept of third generation of human rights do not imply that one generation is more important than another. They are understood as a cumulative, overlapping, and interdependent or interpreting rights. The third generation of human rights are those rights that go beyond the mere civil and social rights, and it includes group and the collective right to economic and social development, right to natural resources, right to communicate, right to participation in cultural heritage, and right to intergenerational equality and sustainability. There are collective rights or group rights. Rights to environment, right to environment, you can say it is the best example of the third generation of human rights, because it is not for any individual, it is for the group, it is for all, and any member of the group can not only enjoy the same right, but to enforce it, he can file a case to implement in any jurisdiction as if it is statutorily guaranteed. Coming to the conclusion, friends, on the human rights issue, as we have discussed, that international community is devoted to protect the right of workers, so it adopt the number of conventions and also implemented those conventions through its domestic law. Here, I wanted to give some special impression, particularly related with the labor issue. It is my purely personal view, and I may be wrong, but I think that law which is meant for the protection of workers that have been described as a labor law. But I think it should be described as a human right of labor. If that will be dealt in this way, I think that it will give an extra weightage to the labor issues and it will lead in the right direction. If it will be accepted, there will be another benefit. So any coming government will be not simply able to play with the human rights of the workers. It is also very much essential to create a public awareness in regard to the protection of the rights of the workers as a human right. So friends, coming to the second point, and as I promised that I will discuss the globalization issue also. So as you are aware that prior to the 1990, India was adopting the closed economy, but after that it opened the door for all the people of the world. No doubt, it was a great step towards the economy building, but unfortunately, the vulnerability of the labor has significantly increased after this period. Opening of the market, privatization and withdrawal of the state from key areas have been roots of their problem. The demand of the rapid development have left many homeless and deprived many of their traditional sources of the livelihood. So the question is that firstly, that what is globalization? You can imagine that in its common parlance, the globalization is a state of free economic operation amongst various nations who are agree in principle that the entire globe is a single unit and consequently there should not be any boundary among the nations, particularly the economic boundary or economic restriction. It plays its role when a country provides a free platform to other countries without striking tariff or other boundaries. It is undoubtedly true that acceptance of and implementation of globalization is a need of time, and without it the country can't compete with others. It is also considered as the only and indissoluble means of economic growth. In its operational reality, the concept of globalization requires liberalizing the old system of restricted market policy and demands that market boundary of each and every country must be free access, and one should not maintain a monopoly over it only for its citizen or only for their businessmen. However, the second phase of the coin is compelling to remark that it may be only a dream for the host country. Because as regarding the political, social, economical power, all countries are not equal. Then how they can compete and maintain their existence in the market if such country will be bound to open its market boundaries for other countries? Undoubtedly, the wealthy country will enter into their home's market, will destroy them and in founded competition, and will finally defeat them in their own market further. As privatization, is the outcome and necessary feature of the concept of globalization. Therefore, in some jurisdiction, a bulk of economy can be controlled and held by one or few businessmen, mainly in the form of multinational corporations. So, in regard to the globalization, the main question is it beneficial to the common man of the country? Let us take a hypothetical situation to check. You can imagine the price of wheat in America is 20 rupees and India is the 30 rupees. I mean that American wheat is cheaper than the Indian wheat. I, Rajneesh Patel, for my personal use, wanted to purchase wheat from America. Or there is a businessman, Mr. X, who is also willing to purchase it for the purpose of his trade or commerce. Similarly, there is an American company, it wanted to sell the wheat in India. Here the question is, can I purchase it? Can the Mr. X, the businessman, he can purchase it, or the American company can sell it to us? Do you think that answer will be positive? Oh yes, it is definitely. We can, and the Indian government is not able to restrict our import tariff, which would be badly affect our liberty to purchase it, or the company's right to sell it. How it become possible? Do you know? It become possible only due to the policy of globalization, which mandate the signatory of tribes that they shall open their boundaries for the other member nations, and they will not restrict or impose any type of tariff against them. So therefore, if it will be permitted, then it will be better for the economy. We all know, and up to a significant limit, it is true also. But as we are concerned with the general public, we are concerned with the labor class, again the same question is whether it is beneficial to them also. Let us check again. Dear friends, it is very true that globalization policy, if it will be implemented, then it will create a tough competition between seller and service provider. And therefore the articles, the goods, the services will be available to the public at a cheaper cost and probably with a better quality. Here we can take the example of egg, we can take the example of cars, we can take the examples of electronic gadgets like refrigerator, air conditioner and so many. In regard to the price of egg, in India particularly, it is universal. If anyone can get one egg in Uttar Pradesh, Varanasi for 5 rupees, the same will be available at the same rate in Bihar, in Bengal, in all other parts. So this is the effect of globalization. Similarly, after the emergence of globalization concept or adoption of the globalization concept, you know that we are having the various types of cars, various types of vehicles, electronic gadgets, air condition at a very cheaper cost and with a better quality. So definitely, due to this globalization concept, we are having a number of good things in our favor. But it is also true that economic this globalization is a good thing, but one should always remember that this economic globalization will also bring the social globalization and the cultural globalization too. And all these, it will be direct against the local industry or local businessmen. They will be bound to founder their business only due to this concept. It is also true and we can't deny. It means the local would be vocal if the attempt of the government will be with the full-hearted and the ground level, where the schemes produce the real intention, the real picture. Otherwise, it will remain the mere paperwork or a sweet slogan only. It will cause unemployment also, globalization and impact on the various sections of the Indian society and economy are creating altogether new problem, demanding the new solution. The employment protect the skilled, semi-skilled and unskilled workers and becoming black and downaging rights and snatching the golden handshake become the common. They have generated serious long-term repercussion for the Indian labor. So this is all about the globalization concept. Now moving to the main issue, and friends, I am coming to the labor issue. Entire labor laws can be divided into the four types of labor laws there. That is industrial relation, social security, welfare legislation and regulatory legislation. So these are the 4 types of labor laws, Friends, as you are aware about this fact that very recently the Indian government has passed 4 labor codes also, which amalgamated about 29 legislation into 4 codes. Undoubtedly, it was a great step taken by the government, and this is done on the recommendation of the second Labour Commission on Labour in the year of 2002. So, firstly, I would like to have a little focus on these 4 types of labor laws. I am not talking about the labor codes, we will take the same, but here I will discuss the 4 types of labor laws. So the first kind of labor law is that is known as the industrial relation. Actually, the law related to industrial relation are mainly concerned for the establishment, and it defines the relation between labor and the capital. Prior to this new code of social industrial relation of 2020, Industrial Dispute Act 1947, Trade Union Act of 1926, Industrial Employment Standing Order Act were the famous example of the industrial relation legislation in India. Secondly, coming to the social security laws, the law relating to social security are concerned with the payment of certain amount to secure the future of the labor as well as in case of some necessity. The Workmen Compensation Act 1923 was the clear example for the same. Thirdly, there are some welfare legislation which provide a measure of welfare to the workers. Factory Act 1948, Payment of Bonus Act 1961 were the example. And lastly, there are some regulatory legislation, labor legislations. Actually, certain piece of labor legislation governs and regulate the contract and agreement of the employment that can be classified as a regulatory labor legislation. For example, Contract Regulation Act 1972, Payment of Wages Act 1936, Minimum Wages Act 1948 were the example. So, we have seen the 4 types of labor legislation. Now, the question is, friends, how this labor legislation will be implemented in our India. So, particularly in our country, we have 2 types of mechanism to enforce the protection of rights of workers. The first one is the state mechanism, the second is the group mechanism. In regard to the state mechanism, there are judicial mechanism which can be divided into 2 parts. The first is Supreme Court and then the High Court. So these are the regular courts, and after that we are also having some state mechanism in the form of various committees and other systems, like there are mainly 3 state mechanism. One is known as conciliation. It includes Works Committee and Conciliation Officer. The second is arbitration. In the concept of arbitration, the party, means the labor and the employer, they will free to choose their own judge, and that judge will be named as the arbitrator. So, arbitrator will decide and take the matter, and his decision will be binding over the party. And the third point, or the third system of mechanism is called as adjudication. It includes the industrial tribunals, the national tribunals, the labor courts, and other authorities under the different legislations.
So friends, after discussing the 4 types of labor laws, now I think we should move to the main issue, that what are the effects which have been implemented by these 4 new codes. First of all, I will take the wage code or wages code. This wages code brought a number of new provisions for the protection and in the interest of labor or working class. Particularly, the Minimum Wages Act 1948, which was applicable only to the scheduled employment. But right now, the wage code of 2019, it will be applicable to all the institutions, all the establishment, and this establishment covers any place where any industry, trade or business is going on. So it is very particular, and that's why by this new provision, actually it widened the the scope of this wages code. So it is fruitful to the working class. Secondly, in our earlier provisions of the various labor laws, the word workman was used. But right now, this code, these all codes, they are using the word workers. And this term workers is definitely the gender neutral. Like the Minimum Wages Act, there is one Equal Remuneration Act of 1976. Even this act was also applicable to the workers who are working in any notified establishment. It means to implement the law, notification was necessary, and some of the state governments they never bother to take any to notify any institution. But right now, automatically this act will apply and it will be implemented. So again, it is a very great step. Similarly, the payment of wages, this code is also widened, and the coverage of the code is extended to all the establishment. Okay, so these are some the provisions which are the new provisions under the new code. Now the central government is also authorized to announce floor wages, and that will be beneficial to the working class. And finally, it is also written there that overtime wages shall not be less than the overtime rate shall not be less than twice. This provision shall apply to all the institutions. Similarly, it is also a new provision that the time limit of the payment of wages is fixed up to the 7th day of the month. Earlier it was the 10th day of the month. And it is also a new provision that deduction of wages was earlier allowed up to the 75% of the total amount, but now it is decreased to the 50%. So this is about the wage code. Now moving to the Social Security Code of 2020. Friends, like this other codes, this Social Security Code is also, the scope of these codes is also widened. First of all, the benefit of this Social Security measures, the Social Security funds, it shall be made available to all the workers, even who are working under the unorganized sector. This is very much important, and actually it was much awaited program of the various government. So that this dream comes true, and it will be true, I hope. Similarly, a copy of letter of appointment, this concept is also added by this new code. Earlier it was not available. Some benefits are also given to the interstate migrant workers, and they shall also enjoy the various benefits as given under the Act. And not only this, they will get at least one time journey allowances in a year. So these are some new provisions for the working class, particularly the unorganized sector. And one special thing which is added by the new code, and that is definition of the worker is actually extended right now. Earlier, it was confined to the person who is working under the supervision of the employer, but now the interstate migrant workers, the platform workers, the film industry workers, the construction workers, and also the gig workers have been included under the definition of the term workers. So definitely they all will be benefited by this new code, and it will be a great step in the protection of their human rights. Coming to the third code, that is known as the Occupational Safety, Health and Working Condition Code. In this code, earlier the definition of the factory was defined, and which was required at least 20 workers. That is now extended to the 40 workers. And manpower limits is earlier, which was who were employed by the contractor, that was 50, but it is now it means instead of 20 it will be the now 50. The daily working hour, which was 9 hours, you will be also remember that it was also a SEAD case on this point, but right now it is said that the 8 hour will be the sufficient. And the much special thing that women will be entitled now to employed in all type of establishment for all type of work, even in the night shift. It was also a much awaited program of the government, and now this dream becomes true. And finally, friends, coming to the last segment, that is the Industrial Relation Code. And here I wanted to say one special thing, that in comparison with all the three codes, this code is a little bit disputed, and the reason is obvious, because prior to this period, means when these codes will be applicable, there was Industrial Disputes Act, there was Standing Order Act. To implement the provision of Standing Order Act, to implement the provisions of the Industrial Disputes Act 1947, at least 100 workers were required. It means if there are in any industry there are 100 workers, then the provision shall apply. But right now the code is saying, our code is requiring 300 workers, and this point is a little bit disputed, because if any industry is not having the 300 workers, it means the provision of the industrial code will not apply to it. So this is a problematic feature, and I hope that before implementing this code, the government will think over the issue. Secondly, friends, this code is also recognizing the concept of hire and fire. Why I am saying the same? Because in our Industrial Disputes Act, which is known as the guardian of the workers, the guardian of workmen, in that act it is clearly mentioned that before retrenching any workman, or before taking him, giving the notice of layoff, you have to give the notice first, and you have to give some compensation amount. The same is continuing, no doubt. But what happened, as this act will apply only to that type of industry which are having 300 workers, actually by this increasing number, it is recognizing the concept of hire and fire, and it is giving the extra, or I think unfettered power to the employers, that will be, I think, against the welfare of the workers, the interest of the workers, as well as the human right. Okay. One more thing, that in our earlier act, that was Industrial Dispute, regularly I am saying that in our earlier act of the Industrial Dispute Act, it didn't mean that earlier this Industrial Dispute Act is removed finally. No, because even these all four codes are not made applicable till now. Okay, so just I was taking the third point, that in Industrial Disputes Act, before calling any strike or even the lockout, it was required that you have to give the 14-day notice. The same is continuing. But what change made by this new code, that in early period, or in an Industrial Disputes Act, it was required only for an institution which is coming under the purview of public utility services, which is directly concerned with the public. But right now, this code is saying that you will be required to give notice in any type of institution, whether you are coming under the purview of public utility service or general services. Okay, so I think it is also against the trade union movement, and I think government should also think over the issue. And finally, with a request that which may be the today's crux of the today's session, that at present we are using the term labor laws or labor codes. Instead of this labor code or labor laws, we should use the term human right of workers. And if this human right of worker word will be used, I think it will be more fruitful, as well as it will give more impression, and the government will be not able to play the rights of the workers. So thank you friends, thank you all.